Hello, everyone, and welcome to another episode of Talking Law. Today, we're going to be talking about something really interesting again in the off-the-plan space, specifically whether a buyer under an off-the-plan contract can actually onsell that contract. It's a question that gets asked of me many, many times, and it leads me to believe that many people out there have a misunderstanding about how on-selling works if you're under an off-the-plan contract. So listen up to this episode because this will dispel any myths and misunderstandings you may have about how this all works. So let's get into it. So while you're under contract with a developer in an off-the-plan, can you on-sell? That is the question. The short answer is it depends. And it depends because the critical document to look at is your contract of sale with your developer. Now, hopefully, as I have suggested and expressed and recommended before many, many times, that you have got pre-contract advice before you sign that off-the-plan contract. And as part of that pre-contract advice, that your lawyer, hopefully experienced in this area of law, would have looked for clauses in your contract that dictate whether you can or cannot onsell your lot. And if you can, what does that process look like and whether there are any restrictions. So it's often missed when the review occurs. I know this because I hear this from other buyers that come to us when they've been represented by someone else previously. So it is very critical buyers understand this because not just for those speculative buyers who actually enter into an off-the-plan contract with the specific intention of on-selling and making a profit. There's nothing wrong with that. There are obviously risks associated with that. But also if your circumstances change and you're looking to on-sell and get out of your contract. But when I say get out of your contract, as I've advised and stated previously in other episodes, you can't really ever get out of your contract once you've committed in and off the plan, which is one of the reasons, many reasons why buyers need to get that critical pre-contract advice so they understand what they're getting into with their eyes wide open before they sign their contract. Now, what does your contract look like in terms of on-selling and whether there are conditions, restrictions, parameters that you have to meet? So what we see in practice pretty much in most of the off-the-plan contracts, it's one of three things. The first is a clause that will be entitled first right of refusal. We'll get back to that in a minute, explain to you what that means. The second option is that there is a specific clause about whether it's called an assignment or on-sell of your lot, where you have to seek the developer's consent, and the developer may or may not have to give that consent acting reasonably. Sometimes these clauses say, look, the developer has an absolute discretion to decide whether they give that consent or not. Now, whether that's considered a fair or unfair contract term under the umbrella of the unfair contract terms regime that we've talked about a few times on Talking Law, remains to be seen because you can only assess that when you look at the contract in its entirety. So putting that aside, that's your second type of situation. Your third situation is where the contract is just silent as to whether you can actually onsell. Now, that doesn't happen very often, but sometimes it does. And my view in that third scenario is if the contract is silent, well, you can pretty much onsell. But let's get back to the first option because that's the one that is commonly seen in off-the-plan contracts, particularly projects on the Gold Coast. So first right of refusal, you may have already heard the term previously, but what does that mean in the context of an off-the-plan contract? So it means that you as a buyer have to offer it back to the developer first. Why would the developer want that? It's primarily there for the developer to try and control the values of lots. Okay, so that's pretty critical for a developer in a project to get to the end of a project and perhaps have unsold developer lots. If there are other lots that have been under contract that have sold and have got valuations based on those prices, it may have an impact on the value of the unsold lots. But notwithstanding that, the process is you offer it back to the developer first. Now, critical that that whole clause is read and advised to you properly, because within that clause, and there's usually a few clauses under the first right of refusal heading. It explains to you what that means, what's the process, what's the timing. So usually the offer made back to the developer by the buyer has to be in writing, of course. You can nominate usually any price you want. Typically, you will always put a higher price than your original price. One, because you're looking for a profit, but two, you need to cover all of your costs. And that includes stamp duty and other costs, which we'll get to later. And then the developer has a short period of time to decide if they want to accept the offer or not. So usually 14 days or 21 days. Once the developer comes back and says one of two things, yes, I'm interested, and then there's a process to follow there. Well, we haven't typically seen that in any off the plan contracts yet. Or the second is, no, I'm not interested, so I don't accept the offer. Now, at that point, the buyer can then go and sell on the open market. And typically in these clauses, there's a clawback. I suppose I could call it that, because what the clause may also say is that if the buyer can't find a buyer to onsell, third-party buyer, then within 90 days, then they've got to reoffer it back to the developer again. So it's really critical to understand that process. The other thing that you can possibly get caught out with, again, if you don't get that pre-contract advice, or you don't get it from someone who's qualified, who knows what they're looking for, because the way that these clauses are drafted are done, I won't say cleverly, but they're done in a way that it's really, if you don't know what you're looking for, it's like looking for a needle in a haystack. And so we know what we're looking for specifically in these types of clauses. And usually it's in different parts of the contract. You've got to marry up the definitions part with the clause. So you need to know exactly what you're looking for. So sometimes these clauses also put parameters and conditions on the buyer that once they actually own the lot, so once you get through your contract period, you actually settle on your lot, you become the lot owner, it's your property, great. But sometimes these clauses say, okay, then, if you want to now sell that lot after settlement, you just can't sell it to anyone, and you can't just sell it however you want on whatever conditions you want. You've got to offer it to the developer first. Now, that's not something that is looked at very favorably by a buyer. And I know this for a fact. There are some projects on the Gold Coast that have these clauses, and I have specifically negotiated that clause, the first right of refusal clause, ceases at settlement. It's very important for buyers because buyers need to have complete control of their property once they settle, and they shouldn't be hamstrung in those situations. So very important to look out for that. So if that's the case, let's move on to, well, how does it all work in terms of the practicalities of an onsell? Does it mean that I'm actually out of my contract? The short answer is no. So this is the misunderstanding. Some buyers think if I onsell, I'm out. Happy days. Actually, it's not. So what happens is you've got two contracts on foot. You've still got your original contract with the developer, and that remains on foot all the time up to completion. But over here, if you happen to onsell, you've got your own contract over here with a third-party buyer, and you as the original buyer act as a seller, and you're onselling to that third-party buyer. So you've got these two contracts that stay on foot with different parties. And when it comes time to settlement, the idea, of course, is that the third-party buyer that you've negotiated with and that you've signed up on this contract over here actually settles with the developer, right, instead of you at settlement. And only at that particular time you get to bow out and get your 10% deposit. Now, why does that happen? Because the developer wants to keep you on the hook in case your third-party buyer over here defaults. Perfectly reasonable and logical. So unless the developer actually agrees to rescind your contract, which is rare and doesn't happen very often in a situation where you want to onsell to someone else, then you are in that contract until the end. You would want your third-party buyer to settle so you don't have to. And if your third-party buyer does default, well, guess what? You're on the hook for settling with the developer. And if you don't, your 10% deposit will be lost and you'll be up for all sorts of nasty things because you have defaulted under a contract. So you really want to make sure that your third-party buyer over here is pretty genuine and they actually want to settle on this and they're capable as much as you can ascertain that yourself or through your selling agent. Really, really important. And it's important to get a selling agent that understands off the plan contracts and on sales, so they can also have that conversation with the end buyer, which is critical because that's part of their own assessment about whether that buyer really wants to get into the project, if they're genuine, if they want to settle on it. So really, really important. Now, as part of that on sale contract, you get your 10% deposit as well. So you would have paid your 10% deposit up front under your developer contract. But you, in your on sale contract with that third party buyer, of course, you also get your 10% deposit. That's your security. And that 10% deposit stays in your lawyer's trust account. So there's your security in case that third party buyer defaults. Really important. You wouldn't settle on anything other than 10%. If you've also paid 10%, particularly, or even if you've only paid 5%, there's no reason why you couldn't ask for 10%. In any event, that's your security. But make no mistake, if that third party buyer defaults, you are on the hook for settling with the developer. So that's how that all works. The other practicality is stamp duty. Now, a lot of buyers misunderstand, or they just have this misconception, of course, that if they on-sell, then they minimize their costs. So unfortunately, in Queensland, in an on-sale situation, you've got these two contracts on foot. You, as the original buyer, you still pay your stamp duty on that contract, even though you don't settle with the developer. It's one of those quirky things, unfortunately. In Queensland, the end buyer also pays duty. So Queensland Revenue gets a double whammy. So whether that's right or not is a discussion for another day. Perhaps we'll never discuss that, but in any event, it is what it is. So Queensland Revenue gets 2 bites of the cherry, gets 2 lots of taxes. So you need to cater for that when you're on selling to a third party buyer, and you need to make sure that that on sale price is high enough to obviously give yourself a profit and to cover stamp duty and legal costs. Now let's talk about legal costs, and well, not so much the costs, but understanding that there is a fee payable to your lawyer to prepare this off the plan contract. This is the another part to this whole process. So if you have a lawyer that is experienced and off the plan, hopefully you did from the beginning, they should have the experience and knowledge and know-how to be able to prepare that on-sale contract over here with your third-party buyer. And why is that important? Because you acting as a seller in your on-sale contract, you then have the obligation at law, like the developer did, to properly disclose to your end buyer everything to do with that project. And then you may think, oh, how do I do that? I'm not the developer. Well, it's easy when you know how, and we know how. So your on-sale contract is not just a standard RIQ. It can't be. It has to be an off-the-plan contract itself that mirrors the original contract and disclosure statement. And there are ways to do that, and we know how to do that. There are various special conditions that need to be drafted in there. And along the way, if you ever get further disclosure statements by that original developer, you then have to continue to disclose that to your end buyer. And why do you care about this? Because under the legislation in Queensland, if proper disclosure has not been made to a buyer in an off-the-plan contract, that buyer has a right of termination. So you don't want to ever give that end buyer over here any rights at all, any loopholes to get out of your contract. So it needs to be done properly and by someone who knows what they're doing. So that's the process with the contract, the on-sale contract. There's a couple of more things to talk about before we finish up, and really important stuff, because these are all the practical things that parties may not understand, and that's why I do these episodes, so you really know or have as much knowledge as possible before you get into these transactions. So the on-sale contracts, so you've got your contract over here with the developer and your on-sale contract with the buyer. These types of contracts, and I'll call it the property transaction, where there's 3 parties involved. Currently in Queensland, this type of property transaction is not capable of functioning on a PEXA workspace. What does that mean? So since the 23rd of February 2023, Queensland has become a e-conveyancing mandate state. And that means that all property transactions that are capable of being completed on PEXA, in a PEXA workspace, on the PEXA platform electronically, have to be. If they're not capable, and there are a few exemptions and instruments that are just not capable of being transacted on PEXA, they have to be a paper settlement. Okay, so PEXA at the moment has no workaround, in a nutshell, for these types of third-party transactions. It's just not possible. And that's not because PEXA is, sitting around twiddling their thumbs and not really doing anything about it, even though they know that there's a need in the market. PEXA is also contingent or reliant on, I should say, other parties that will help them bring these types of transactions to the PEXA platform, and they are Queensland Revenue and Queensland Land Titles, and also part of the legislation. So there's a whole range of things for these types of transactions to be conducted electronically. It's not possible yet. We're hoping in the future it does. So why do you care? You want to care because your lawyer, whoever you use to settle this, they really need to be proficient in paper settlements. And you think, oh, shouldn't they know about paper settlements? Well, no, not necessarily, because we've been on the other side with law firms who have no idea how to do a paper settlement because, one, they've just come into the legal profession and they've never, ever had all these years of experience like we have, where paper settlements were the only type of transaction that could ever be affected, and then electronic settlements came on board. Or they've just never been trained in that particular law firm because that law firm might have assumed everything's electronic, which it is not. So we've actually helped those firms along the way who have been on the other side to us to get a matter settled by paper. And paper means wet signatures on documents. It means documents being posted, delivered. Seems a bit archaic in this day and age. And it also means bank checks. Doesn't mean electronic payments. So, trundling off to the bank and getting bank checks, which we haven't done in quite a long time other than these types of transactions, and then clients being charged bank check fees. So there is a different process altogether. You would hope that your lawyer understands paper settlements. So that's one of the major practicalities to understand. And that can cause delays with the settlement process itself, because you've got people running around having to sign paper documents and getting those documents posted and delivered to various parties in Queensland, which could be Gold Coast to Brisbane, North Queensland, who knows? So, or even interstate. So that's really critical to understand. And before we finish, there's some other practicalities for the end buyer that I thought I'd touch upon really quickly. And it's something that the end buyer may not have been told by their own lawyer if their lawyer doesn't understand the practice of off-the-plan contracts that are onselling or on-sale contracts. And that is this, that when a third-party buyer decides that they want to buy an apartment off the plan through the original buyer, not from the developer, there's no room for negotiation at all, because what the end buyer is doing is they're buying this apartment on the basis of accepting all of the existing terms and conditions that have already been negotiated by that original buyer. Because it's the original buyer that has the contract with the developer. It's not the end buyer that has the contract or relationship with the developer. So the end buyer has really limited circumstances, if at all, to negotiate anything. Well, they certainly can't negotiate with the developer. That's off the table. So they need to understand that. If there's something that they can negotiate with the original buyer, their seller, then that's possible potentially. But whatever is negotiated with that buyer, who becomes the seller, in their contract can't be something that changes the terms of the original off-the-plan contract. And that's something really critical to understand. So at a practical level, what does that mean? So pre-settlement inspections. So something that people don't think about often in an on-sale. In the original contract that the buyer has with the developer, the buyer has usually a pre-settlement inspection right, and it says only the buyer can attend. In the on-sale contract, the original buyer, you see, really doesn't care about doing the pre-settlement inspection at the end of the project, because they're not the ones that are going to settle. It's their buyer over here, the third-party buyer. How does that third-party buyer get their pre-settlement inspection right? So that's one of the many practical issues that really needs to be thought through. Also, assignment of manufacturer's warranties that the original buyer would have obtained from the developer after settlement. Also, rectification of defects. That right is given to the original buyer. How does that flow through to the end buyer? So all of these are very important for the end buyer to understand, because often this end buyer over here doesn't get proper advice from someone who's experienced and off the plan, and all these practical issues just get left by the wayside. And it's only until the end, when the pointy end, comes around, that is settlement, that all these things are only thought of then, and everyone's running around chasing their tail. So hopefully you've enjoyed today's episode. I hope that's brought some valuable information to a buyer who wants to onsell, and also a third-party buyer who wants to contract in an onsell contract as well. Please feel free to jump on and subscribe to our channel, and you'll be able to receive all of our episodes. We currently have over 270 episodes online, and you'll be able to have those at any time and view them at any time of the day or night. So hope you've enjoyed this, and we'll see you next time.